We don't mess with anything in terms of the term victim. We just change offender to justice impacted individual.
That is State Senator Robert Peters this spring talking about changing definitions in a law that was signed by Governor J.B. Pritzker on Friday alongside 58 other measures. Good morning. I'm Greg Bishop. Thanks for taking time with us each and every weekday morning for Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us each and every weekday morning as we break down the stories impacting you right here in the state of Illinois. So Fridays seem to be, during the summertime, a time for Governor J.B. Pritzker to release large numbers of bills that have been signed. The Illinois legislature, during spring session, were pretty busy. They spent a lot of time passing legislation. More than 450 different bills were passed. And the governor's moved through a lot of them. And on Friday, he announced that he signed 59 bills in one email. Now, he does do bill signing ceremonies. We know this. We cover these. For instance, when he signs the budget, he has a lot of people around him, and they get together and they talk about the importance of the legislation that he signs. So, we get these what seem to be kind of paintings of sorts of the governor at the center of the table and getting surrounded by advocates for legislation, and he signs a J, and then he takes another pen, and then he signs the rest of the J, and then he takes another pen, then he signs the period, or he doesn't put periods in his name. So he signs another B, and then the Pritzker, he uses like 15 pens, and he signs all this legislation. So he does those bill signing ceremonies where then he'll take questions afterwards, and a lot of times it's off-topic Q&A. Then he'll put out news releases about other legislation he will sign. And on Friday, he did put out a statement concerning one particular piece of legislation that he did enact, and that dealt with Sign Language Equity and Access Act. So this was a standalone news release that he released on Friday. The governor signing Senate Bill 3762. It's the Language Equity and Access Act. The bill requires the governor's office of New Americans, in partnership with the Illinois Department of Human Services, to craft and implement and oversee statewide language access requirements. The legislation seeks to ensure that language proficiency is not a barrier for Illinoisans seeking access to state agency resources. So the governor's office of New Americans, and that was something that he announced was signed on Friday. With a standalone news release, there was not a news conference and a bill signing ceremony. But if you were hanging out late on a Friday looking at thecentersquare.com, then you also saw that the governor announced a bunch of bills being signed. And he took bill action in this announcement, which, if you look at it, and we'll just go through here, there are 20 some odd House bills that he signed and 30 some odd Senate bills that he signed. And you can just scroll through and look at all these yourself. There's a lot of legislation there. And no boy, I think it was 59 measures altogether enacted. Some taking effect immediately, others taking effect on January 1st of 2025, others taking effect January 1st of 2026. So what is it that the governor signed here? I went through all 59, looked at the descriptions that the governor had given by his office, and I picked up some of the more prescient ones. In particular, one impacting businesses is the Biometric Information Privacy Act update. And this is actually something that they've been looking for, the business community. Did they get everything they wanted? No, not necessarily. But effective immediately, Senate Bill 2979. It expands the definition of written release to include electronic signatures. It would make multiple violations of the Biometric Information Privacy Act a single violation if committed against one individual. So business groups, they sought such changes following several high-profile lawsuits against employers. And if you've been following that particular case, I mean, the Biometric Information Privacy Act, it's been around since 2008. And it's probably the strongest biometric information privacy law in the country, and it's while it passed in 2008, little did we know just how much, well, some of us knew back then how much biometric information was going to be used as identification in a variety of different ways. It was already being used back then. I mean, in the Iraq War, they were taking iris scans of suspected terrorists. Your fingerprint is a biometric marker. The way the distance your eyes are from your lips, the length of your nose, all of these factors in a face are indeed biometric information and individual to you, the individual. Even if you grow a beard, they can still tell, just how far away your eyes are from your lips, and everybody's different. So regardless, 2008, Illinois passes the strongest law in the country, some say, to be protecting biometric information privacy. But then we started seeing lawsuits, and I think the big one that we saw up front was dealing with a kid who was going to Six Flags, and he signed up with his thumb without his parents' permission. So they sued, and they got a settlement. Then you had other cases pop up. You remember Facebook? They had to settle for like $200 million. A lot of you may have gotten a $400 check or so. Snapchat, Google, I think there's a lawsuit against TikTok. Regardless, a lot of lawsuits started stacking up, including one against White Castle, who was using the thumbprint for their employees to log in and log out of work. And then there was a lawsuit, and ultimately that lawsuit brought with it the potential of billions of dollars in penalties. And that's why they had to bring this law around, Senate Bill 2979, to, instead of making it where one person could have tons of infractions against their employer, that one person can only get one infraction against their employer if they don't follow the proper protocols to get permission. Something else with the Biometric Information Privacy Act that I just think is important people know, and this is a big bill that the governor did sign. There was litigation that went to the Illinois Supreme Court about whether or not they could do biometric information privacy for nurses to get access to certain types of medications to give to patients, like strong opioids, for instance. Those are behind like a biometric access lockbox. Well, nurses were concerned that violated their BIPA rights, and then that went to the courts and all the way up to the Illinois Supreme Court, and I believe that they did say that this is separate. Nurses can be, the hospital space can be separate. So that's one big bill that the governor signed on Friday. Again, no signing ceremony. He just went ahead and signed the measure. So interesting to see that. Then again, some other things going on here impacting employers. House Bill 3763 allows employees to request from employers contracts, policies, handbooks, press releases, discrimination reports, and any other similar documents about that employee. Another measure in the criminal justice space, House Bill 4409. It grants the Adult Redeploy Illinois program more flexibility in funding allocation through its grants and awards, and it adds more people to an oversight board. But this measure drew controversy whenever it passed because, well, it was revealed that the definition of the participants in the Adult Redeploy Illinois program would change. These are individuals who were caught breaking the law. And you would consider them, in most contexts, a criminal. But that's being changed. Just the individuals in the Adult Redeploy Illinois program. I want to make that clear. This isn't changing the word criminal across all of Illinois' criminal justice system. It's just for the Adult Redeploy Illinois program. But it's interesting. It sparked debate about why they're going about looking to change the definition of criminal to what? Justice impacted individual. State Senator Robert Peters out of Chicago, Democrat, he was asked by Senator Steve McClure to, well, I guess elaborate what exactly is a justice impacted individual.
That means someone who's been impacted by the criminal justice system and is an individual.
Okay, so are you changing what victims are referred to? Are they going to be referred to as criminally impacted individuals?
Sometimes we refer to victims as survivors of violent crime, sometimes survivors of domestic violence. So we use multiple terms for a lot of different people for a lot of different things.
So are you saying the bill changes the word victims multiple times, or is there no change at all to the word victims within the legislation? Or is the word victims not in the legislation at all?
Well, we don't mess with anything in terms of the term victim. We just change offender to justice impacted individual.
So So there's been a tremendous rush in this chamber to take away penalties, take away accurate language to reflect criminal behavior, take away crimes. Most importantly, there seems to be this incredible rush to take away all accountability for people that commit crimes. If a person is going to get on the right path, they have to know that they did something wrong. And this apologizing for the criminal, the person who chooses to commit crimes, to the detriment of our victims, the people that don't choose to be victims of crimes, is absolutely incredible.
So it's interesting debate there. It even went further on the Senate floor, and this was video that was seen around the world. All kinds of different social media users were sharing this particular clip on TikTok, on X. It got millions of impressions, but here is more of the debate with Robert Peters talking about the bill in particular, but then Senator Terry Bryant's worried about the continuous change of definitions here.
We're adding the Department of Corrections, adding Human Services, adding Sangamon and Cook County adult probation, and 2 members who've experienced the ARI system as offenders or justice-impacted individual.
It might seem like a small thing. I mean, obviously, changing a term can have a positive or negative impact when we do that. But I would say that over and over again, we keep changing the names for how we are referring to those who have entered into criminal activity. And each time we make that change, each agency has to make that change on every one of their documents. So right now in the Department of Corrections, there's multiple changes that have been made, and it's costing thousands and thousands of dollars just to do a name change. So I would ask, why is it necessary to make the name change? Even if the rest of the bill was okay, which I don't think that it is, but even if the rest of it was okay, the name changes may seem like a small thing, but it costs thousands and thousands of dollars to do that.
So, again, the bill itself, the bulk of it, addresses the Adult Redeploy Illinois program, provides more oversight to members on a panel to look over the Adult Redeploy program, but also changes the definition of criminal to justice-impacted individual for those who are participants of the Adult Redeploy Illinois program. Again, just one of the 59 bills that Governor J.B. Pritzker signed on Friday. Measures impacting education that he signed includes House Bill 307, and that extends the opportunities for student athletes to receive compensation in Illinois. That takes effect January 1st. You also have Senate Bill 2872, which takes effect January 1st and allows school districts to provide relaxation activities to students. This also sparked some controversy. In committee, the sponsor of this measure, State's Representative Laura Favor-Dias, she talked about the significance of it.
Senate Bill 2872 allows schools to support students' mental health by allowing, I do want to reiterate, it is permissive, them to offer 20 minutes of relaxation a week to support students' mental health in the form of mindful-based movements, yoga, stretching, meditation, breathing exercises, walking, and stress-relieving activities. This bill also allows for the partnership of local private organizations that could support these efforts. These activities could take place in PE, social emotional learning class, student advisory, or even a new class, because it is permissive.
So you've got the ability for school districts to say, hey, 20 minutes a week. What is that, 5 minutes, 4 minutes a day, 5 days a week? 4 minutes a day relaxation techniques. All right, it could be a variety of different things. Just sitting there in quiet and peace, doing yoga, transcendental meditation, staring at your belly button, whatever the case may be. But the school districts at first were just cautious that, well, they've got only a limited amount of time. John Berkey's with the Large School Association. This is from a House hearing earlier this year during the spring session.
You're going to find, we are very protective of the time in schools because we have so much to get done in the current school day that if we are required to do something more, something has to come out. And so that's why we were opposed to the original bill. We are not in opposition to the bill as it is now because it is a may.
And the difference between shall and may being that if a law says that an agency shall do something, then, that's a requirement. They have to do it. If the letter of the law says they may do something, then it means they could do it if they want to, but then they don't have to. State Representative Blaine Wilhauer during that committee raised questions about, how this could run afoul with some parents' sensibilities.
Is there going to be a specific student or parental opt-out if they explicitly believe that yoga is a spiritual practice that has its basis in Hinduism and Buddhism and, a lot of other things that wouldn't be appropriate for people of other religious beliefs? I believe there needs to be some mechanism that the parents need to know that this spiritual activity is going on in their schools, and there should be an option for an opt-out.
So he asked for that. We'll hear a little bit more from Wilhauer whenever this gets to the floor. And again, this was during spring session. We're just talking about the 59 different bills that Governor J.B. Pritzker signed. Katie Stewart, Democrats from Southern Illinois, she reacted to Wilhauer and others raising concern.
Just like to remind people that all schools say the Pledge of Allegiance every day, and there's a reference to God in there, and there are people that don't believe in God, and yet we still say that Pledge of Allegiance every day. And I'm also a little bit disgusted to point to measures that were taken that save the lives of teachers and administrators and others that work in the school buildings every day. To refer to things that were done as mistakes, I think is really insulting and really diminishes our respect for the profession of those people that work in our buildings every day. This conversation has gotten ridiculous, but thank you very much, Representative, for bringing this forward.
And clearly, some people see focusing on some parents' concerns, even if they're in the minority voices, some people point to those concerns as ridiculous, but others want to say that those people's concerns are important. Wilhauer on the House floor, he gave more detail as to why there's concerns here. It's not just the, parents who have certain sensibilities that might be offended by having their kid learn about transcendental meditation without their consent. But also the taxpayer cost here.
An ex-student of the Chicago Public Schools was just awarded $150,000 from CPS as a result of her filing a lawsuit that forced her to participate in this quiet time program, this meditation program, which has basically been characterized as a thinly veiled Hinduistic religious ritual. This is a very bad idea. There are already cases out here where situations like this have been abused. The Chicago Public Schools has paid money to negate this very issue. So I would strongly encourage a no vote on this.
Regardless, the measure passed, and again, among the 59 bills that Governor J.B. Pritzker signed on Friday. Moving on to other legislation that the governor signed here. Let's just take a look. Senate Bill 2934 impacts laws around hazing. And it says starting January 1st, consent or permission from the hazing victim does not absolve the perpetrator from persecution for hazing. You also have legislation impacting healthcare, several bills here. House Bill 4874 provides pharmacists, prohibits them from refusing to fill a valid opioid prescription just because it's not prescribed electronically. That's effective immediately. Group insurance plans regulated by the state must cover IVF services and annual menopause visits beginning January 1st, 2026. Also effective January 1st, 2026. Again, not next year, a year following. A lot of times insurance changes they give like a long kind of runway of sorts to prepare for it. But also effective January 1st, 2026. Senate Bill 2672 requires insurance companies to cover brand name drugs if there's a shortage of the generic version. Also effective immediately, Senate Bill 2573 requires insurance coverage for wigs worn due to hair loss caused by alopecia, chemotherapy, or radiation treatments effective January 1st, 2025. So those are some of the bills that the governor signed. You can go through, find the story at thecentersquare.com. You can click through and even see for yourself the entire list. I think another one that was interesting was garbage trucks have to cover their garbage truck on certain roadways or something to that effect. So interesting stuff. Obviously, you'll stay up to date here each and every weekday morning with the Center Square, America's Talking Network. Like, subscribe, hit that notification bell, and join us as we tell you what you need to know to get your day started here in the land of Lincoln. I'm Greg Bishop. It is Illinois in Focus Daily. And get the newsletter, subscribe to the podcast, and we'll see you each and every weekday morning here with Illinois in Focus Daily.